Hi, friends. Welcome to Green Card Guys TV. I'm your host, John Ting. I practice immigration law in all 50 states of America and across the world, representing clients to live and work in America legally. Now, today's video is to share why it's important to apply for a waiver if you have entered the country without a visa. Now, you want to listen all the way to the end so you'll understand the complete concept and why this is important. Friends, if you're new to our channel, please click subscribe down below, click the bell so you get all our future notifications, and also smash the like button. And please answer this question. If you haven't applied before, if you have not applied for the waiver and you know you enter the country without a waiver, please tell us what your hesitancy is, because we'll love to see if we can help answer. Now, let me share a story with you. We've had several people come to us in the consultation and tell us that they've already filed a petition to establish that they are married to their USCIS spouse. The most difficult part about this process to get a green card resident status is that if someone has entered the United States without a visa, there are severe consequences. And that is if you have lived in the United States for more than 1 year, 365 days or more, and then you decide after that to leave the United States for whatever reason, it doesn't matter what the reason is. You literally could just put 1 foot outside the United States border and then 1 foot in. And that will be considered that you have triggered the unlawful bar. In a situation that you have lived in the United States 365 days or more, which is very common, then you would have accrued the bar. You would have triggered the bar of the 10-year bar. So that means by default that you cannot obtain any immigration status or even enter the United States if you have that bar. Granted, the government could make mistakes and let someone in a visitor visa, but that is very, very rare. So when clients come to us with this situation, we have to tell them why it's a problem. So when clients come to us with this situation, telling us that their immigrant spouse entered the country without a visa, we have to advise them of why they cannot go to the interview right now. Because after filing a petition, the government, at some point within usually 1 or 2 months, the National Visa Center, which is a separate office outside of USCIS, they will send a welcome letter, essentially, asking you to submit documents to the National Visa Center, which we'll explain that in a separate video. But for this purpose, you cannot go to the interview yet if you entered without a visa, because the law requires that you be legally inspected and admitted into the country in order for you to obtain your resident status. We call that adjustment of status. So you can only do that if, in this situation, if you obtain and apply for a waiver. The longer name is called Provisional Family Unity Waiver. This was created by President Obama during his term through regulation. Before, if you've heard of people waiting many years or a long time, that's because they had to wait outside the United States. That's a different waiver. It's very similar. If you are currently in the US, you want to apply for the one that President Obama created. So now that you know why it's important, let me explain a little bit more about why it's difficult for people in general to apply on their own for the waiver. Now, I'd like to share another story. We've had several people come to our office saying that they've already filed the waiver and it was denied. And I take a look at it, our team takes a look at it, and we read over the decision, the reasoning by USCIS on why it was denied. Sometimes the reason could be because the documentation was lacking. But overall, the USCIS does not understand what the hardship that your U.S. citizen, spouse, or parent would suffer if you had to live and return back to your birth country. It may sound very simple to put the story together, but it's not so much just writing a letter about why you love your spouse. It's not a love letter. This is to explain to USCIS, the U.S. government, the hardship. So that means specifically, literally thinking about what would happen to your U.S. citizen spouse if you had to live in your birth country. Meaning for 10 years, would that mean that, now you shouldn't think, okay, well, we're going to get a divorce. No, think long-term, how your life would be like for yourself and also for your spouse and or your parent, if you have a U.S. citizen parent or a resident parent, on what life would be like. It'll be significantly, of course, more difficult when you have children to raise. We're very experienced on how to explain the story in a way that USCIS officer is able to understand. We can concisely provide the story to the government, but of course, we have to rely on your story. We don't create the facts for you. We ask you the questions and we guide you through the very beginning and all the way to the end. And it's very important to at least consult with an attorney, an immigration attorney, in fact, because if you go speak with another attorney that handles civil law only or criminal law most of the time, and they just dabble in immigration law a little bit, sure, maybe they can help you file a petition, but they're not as versed with the waiver part. It takes a lot of work, a lot of time. We consider it as teamwork when we are working with our clients because we have to ask the questions and guide you through storytelling. It's factual storytelling. And every client's story is different, but we have an outline in a sense with the questions and checklist that we provide you. And if you'd like to know a little history, the president who created and passed the law with this restriction of the 10-year bar, there's also 3-year and 1-year bar, but that was President Clinton, Bill Clinton, and he's a Democrat. So please don't get misguided by Democrat and Republican. Don't get too deep into identity politics. Nonetheless, it is very important that you keep your politician accountable, whether he or she is red or blue, Democrat or Republican. They need to be held accountable, especially now that a president is Democrat and they have been saying that they want to work on immigration reform since at least who knows how long. It's been at least 2 decades. So again, what can we do for you? And that is guide you through A to Z from the very beginning to end until you get your resident status. The waiver step is just one step in a big picture of the 3-step process, which is step 1, the petition, step 2, the waiver, and step 3 is the consular processing, where you have the interview in your birth country. So yes, you do still have to go to your birth country for the interview. However, before the interview is scheduled by the Department of State, you will have a waiver approved. Of course, we can't guarantee that, but that is the goal. The waiver is necessary because it will waive the 10-year restriction. If you have some more questions about this waiver process, please leave a question below. We'll try our best to answer it in a public forum. Again, if you're new to our channel, please click subscribe down below, click the bell, smash the like button, and also share the video to your friends. If you know someone who is going through this process or about to, we really want to be able to share value with you so that you are fully aware of what you're getting into. Attorney fees can be expensive. So I understand if you want to try to file on your own, but keep in mind, if something negative happens, the government fee is at least $715. And Department of Homeland Security has already published a final rule to increase those fees to almost $1,000. So at least have a consultation with an immigration attorney. I think that's very important for you. Thank you for listening. And until next time, please continue wearing your mask.